Now adjourned. James Wilde.
Thank you very much, Sir Roger. On the evening of the 15th of January this year, Paul Carter, his wife Lisa, and Jade Mace, Lisa's daughter from her first marriage, were killed when Aurelius Chelevisius crashed his car into theirs. 3 innocent lives were ended. I stand here this evening to speak on behalf of my constituent, Summer Mace, who lost her mum, sister, and stepfather that awful evening, and her family and friends who provided 28 victim personal statements to the court. I've met Summer and her father and heard just a little bit about the terrible impact this crime has had on them and their wider family and friends. And the facts of this case are shocking. The offender's speed was so excessive that a police officer in a marked police vehicle in a lay-by that he passed was unable to note the registration number. Prior to the crash, he went through 2 red lights, almost causing another collision, and crossed solid white, no overtaking lanes on multiple occasions. Other motorists on the road that night said he was travelling at speeds of 100 miles an hour and struggling to stay in control of the vehicle, including when the crash happened, where he was on the wrong side of the road and unable to get back to the left-hand lane. All of this while on a cocktail of drugs, including being 15 times over the limit for crystal meth and with high levels of cannabis in his system. The family also told me that CCTV shows Chelevis driving through red lights with blue lights visible in the background, although the judge did not accept he knew he was being followed by the police at the time of this crash. The collision investigator estimates that when the driver crashed into the other vehicle head-on, killing Paul, Lisa and Jade, he was travelling at 91 miles per hour. He was only slightly injured, and on June the 20th this year, Chelevisius was convicted of 3 counts of causing death by dangerous driving. It's frankly unacceptable that after a guilty plea was taken into account, this offender was only sentenced to 10.5 years for killing 3 people. I give way.
Mr Deputy Speaker, can I commend the Honourable Gentleman for North West Norfolk for bringing this forward. He mentioned in his early introduction about that the person was under the influence of drugs, and it probably is a question for the Minister through the Honourable Gentleman, and that's it. While a great emphasis is put upon by government about those drinking over the limit with alcohol, perhaps maybe the same element and the same emphasis isn't done in relation to drugs. And in my constituency, the availability of drugs for people seems to be growing by the day. With that in mind, does the Honourable Gentleman believe that a greater emphasis needs to be put on by government and by the police to do the testing, to catch those people who are under the influence of drugs on the road and thereby reduce the accidents?
I completely agree with the Honourable Gentleman. We're all familiar with the annual Christmas drink driving campaigns and other campaigns throughout the year. And I think Norfolk Police have done some drug testing campaigns as well, and I'd encourage other police forces to do that, because it's not just about alcohol, it is about the drugs, as was the issue in this case. And the primary purpose of the debate that I want to set out tonight is to highlight the serious issues with this case and what it raises in relation to sentencing and the unduly lenient sentencing scheme, as well as proposing some changes to the criminal justice system. In this government's Police Crime Sentencing and Courts Bill 2022, Parliament legislated to increase the maximum sentence for this offence from 14 years to life imprisonment. We did that to reflect the devastation that such crimes have. As Summer wrote in a petition calling for change in our criminal justice system, my family were given a life sentence the day that man killed my loved ones, a life sentence I will never be released from. On the 15th of January, he killed our future lives, thoughts and hopes, as we have none without them. Summer and her family cannot understand why the life sentence they have been dealt has not been imposed on this offender. And that petition that Summer organised has been signed by over 13,000 people, and the family are working alongside other families and charities such as Road Peace and its Fix Our Broken Justice System campaign to try and make a difference. I will give way.
I thank the honourable member for bringing forward this important debate. In my constituency of Somerton and Frome, we were recently shocked by the tragic deaths of two young sisters who were killed as they drove on the A361 bypass near Frome. Their names Liberty and Madison. They were killed because speed limits were ignored on a road that has seen many traffic accidents in these recent years. So does the honourable member agree with me that our road traffic laws are failing and that the victims of criminal driving and their families need confidence that our legal system will deliver justice?
Well, as I say, I think we increased the maximum sentence to life imprisonment for this crime precisely to try and address those concerns. And where I want to come on to now is whether that system is actually working in the sense that courts are imposing the sentences that this Parliament has legislated for them to do so. And in her sentencing remarks, the judge placed this as a level 1 case, the most serious owing to prolonged, persistent and deliberate course of very bad driving. In her sentencing remarks, the judge highlighted the following aggravating factors. 3 people were killed, greatly excessive speed, the driver knowing he was deprived of sufficient sleep, consumption of drugs above the legal limit, the cocktail of drugs in his system, previous convictions for motor offences, driving whilst disqualified, driving with excess alcohol, and 2 accounts of driving with no insurance, and being on police bail for a driving offence at the time and in breach of curfew conditions. 6 aggravating factors. Yet the judge went on to state that a sentence after a trial would have been 14 years. 14 years when the maximum sentence legislated for by this Parliament is life imprisonment. The simple question that many people have is why? And a particular concern in this case is the timeliness of sentencing guidelines. From June 2022, the maximum penalty for causing death by dangerous driving, as I've mentioned, was increased to life imprisonment. Yet it was not until the 1st of July that new sentencing guidelines took effect. How and why can there be such a gap between those 2 things? As it happens, new guidelines had been published on the 15th of June 2023, before the judge passed her sentence, but they were not in effect. They increased the starting point for a level 1 offence from 8 years in custody to 12 years, with a range of 8 to 18 years. Furthermore, my honourable friend, the Solicitor General, personally argued in the Lewis Balcazar Soto case in the Court of Appeal in 2022 that pending the new sentencing guidelines, judges should increase sentences imposed for the most serious offences to reflect the increases in maximum sentence legislated for by this House. Now, having read the judgment carefully and the starting point selected, I don't consider that is what happened in this case when 3 people were killed. My constituents also question the approach to concurrent sentences. The totality guidelines state that where more than 1 death is caused and they are charged in separate accounts, as happened in this case, sentences reflecting the overall criminality would be appropriate and to ensure sentences are just and proportionate. Again, it's difficult to accept that happened in this case where a single concurrent sentence was given. Now, this sentence was referred to the Attorney General on behalf of the family. Our honourable friend, acting on her behalf, declined to refer the matter to the Court of Appeal under the unduly lenient sentence scheme. In the response to the family, he stated that the judge characterised this offence accurately and identified the correct starting point. The question the family have is, what further aggravating factors would justify a higher sentence and a referral? A particular source of anger, and the reason the family lack confidence in this review, is that the letter explaining why the sentence would not be referred talks about the judge as a he, when in fact it was a she. It's perhaps not surprising my constituents who've suffered this very traumatic experience are concerned as a result their case was not looked at properly. So can my honourable friend assure my constituents that it was carefully considered and tell them whether experienced King's Counsel provided advice on this case having reviewed the judgment? And my constituents have a specific request to my honourable friend. Would he agree to meet with me and the family to explain those reasons in more detail directly to them? Sadly, this case is not unique, and Road Peace has highlighted the cases of 4 other families, including Summers, and the fact that no one has yet received a life sentence for this crime. And with the contributions this evening, and a number of other honourable and right honourable members have approached me in the House today, once it was known that this debate was taking place, to highlight similar cases as this that's happened in their constituency, where inadequate sentences have been imposed. Nothing will bring back Lisa Carter, Paul Carter and Jade Mace, but their families are committed to helping make changes to prevent other families experiencing the nightmare that they have. And there are 4 principal areas they've identified as needing action to put victims and their bereaved families' rights ahead of those of offenders. First, the family want a thorough review of all the evidence related to this case. As I've explained, they don't consider it was properly reviewed. And to that end, I hope my honourable friend will agree to meet the family to explain in greater detail how that was considered and also how the unduly lenient sentence test is applied. Second, longer sentences. Parliament legislated for a maximum sentence of life in prison for the most serious cases. Given that, it's appropriate the appropriateness of the sentencing guidelines for this offence are reviewed. How can it be right that someone who kills 3 people in such terrible circumstances could be out of prison in just 7.5 years? 2.5 years each for Lisa, Paul and Jade's lives. These need to be revised in line with Parliament's intent to ensure longer sentences are imposed. And if the unduly lenient scheme threshold is set too cautiously, then it should also be looked at to help inspire public confidence. Third, improving the bail system. As I mentioned, at the time of the crash, the offender was on bail for a driving offence and subject to a curfew. But tagging is not available for police bail. So when he broke the curfew, no one knew. If he had been tagged, it's possible this appalling crime may have been prevented. So one of the changes my constituents and all those who signed the petition want to see is curfews controlled, for example, with a tag and stricter sanctions for failure to comply with bail conditions. This is a very simple, common sense reform to make our bail system more robust, which I hope the government will take forward. Fourth, to ordinary people, it is offensive that multiple lives can be taken, but concurrent rather than consecutive sentences are imposed. Again, consideration should be given for the totality sentencing guidelines to be reviewed for offenders convicted of multiple deaths simultaneously to shift towards imposing consecutive sentences. Finally, thousands of people have signed another petition supporting a lifetime driving ban for people who are convicted of causing death by dangerous driving. In this case, a ban for a period of 8 years was considered appropriate, extended to 15 years, simply to cover some part of the time when he will be in prison. The courts have the powers to impose lifetime bans, and Road Peace is campaigning for them to be applied, and the government should look at this and whether it should become a mandatory element for some cases, because driving is a privilege, it is not a right. I recognise that a number of the issues that I've raised this evening fall to other ministers and other departments, and I seek my honourable friends' assistance and help in ensuring that they are followed up after this debate, whether in writing and also through meetings. There is the opportunity with the Criminal Justice Bill and the Sentencing Bill announced in today's King's Speech, and through the power of the Lord Chancellor to request reviews of sentencing guidelines to ensure tougher sentences are imposed and served. That is what our constituents want and what they expect. For this family, the nightmare will not end, but by making changes, we can try to prevent others from suffering it. This debate is part putting forward those changes. Thank you.
Minister Michael Tomlinson.
Sir Roger, thank you, and I thank my honourable friend, the member for North West Norfolk, for securing this important debate this evening. Sir Roger, dangerous driving, particularly where it results in death or injury, is a most serious offence, and it's rightly condemned by all in this House. And I know quite how seriously my honourable friend takes this issue, and I'm very grateful to him for his engagement in this matter. May I perhaps, through him, particularly thank him for raising the case of his constituents, Paul Carter, Lisa Carter, and Lisa Carter's daughter, Jade Mace. And he sets out his case very clearly with passion and with compassion. Sir Roger, may I offer my sincere condolences to them and pay tribute to what is clearly a very close-knit and loving family, and particularly to Summer, who lost her mother, sister and stepfather in this incident. Their pain and suffering is unimaginable. As the learned judge rightly said at the sentencing hearing, nothing I say nor any sentence I pass can make up for the loss of those 3 lives or assuage the grief of their loved ones. So, Roger, I'll turn to my honourable friend's specific points in a moment, but let me start by setting out some general principles of the scheme that he's rightly referred to, the Unduly Lenient Sentences Scheme, known as the ULS scheme. In exercising my function of reviewing sentences under the ULS scheme, we act, and I act, quasi-judicially. That means that my role and that of the attorney is to act as the guardian in the public interest, and I share my honourable friend's desire to ensure that those responsible for terrible crimes are properly punished. It is right to say that in the vast majority of cases, judges and sentencing judges get it right. They deal with a range of cases that vary in complexity and severity, and I take the opportunity to commend them for their work now. And to put this into context, my honourable friend, out of over 91,000 cases that were dealt with in the Crown Court in 2022, over 1,100 cases were referred to the Attorney General's office, of which 819 were eligible in the ULS scheme. And of those, 139 cases were referred to the Court of Appeal, and the court granted leave to refer 70% of those cases. And those statistics are published on the Attorney General's website. So, Roger, the ULS scheme promotes justice, fairness and consistency, and allows for those sentences which are unduly lenient to be increased. And it's there to correct an error where a judge gets it wrong. But it's important to note that the scheme does not apply to those sentences which are simply just lenient. As the Court of Appeal has said repeatedly, sentencing is an art rather than a science. Leniency is not in and of itself a vice, and that mercy should season justice is a proposition as soundly based in law as it is in literature. That this is a test of undue leniency, and it's a high one. Parliament rightly intended that the Court of Appeal will only grant permission to refer a sentence in exceptional circumstance. For example, if a judge has passed a sentence that falls outside the range of sentences which a judge could properly consider appropriate, or if there has been some gross error in law or principle. I'm going to turn now to the specific offence of causing death by dangerous driving. As my honourable friend said, and I know he welcomed it, the Police, Crime, Sentencing and Courts Act 2022 came into force on the 28th of June. And when it did, there were 2 specific changes, significant changes to the law. Firstly, the increase in the maximum penalties, as has been said, from 14 years to life imprisonment. And as the honourable member, the member for Strangford, noted, it's not just for those under the influence of drink, also for those under the influence of drugs as well. I'm grateful to him for making that point. Secondly, on the minimum disqualification periods, the law has been changed. The government changed the law to increase both the maximum period of imprisonment and the minimum driver disqualification period for those that commit the most serious road traffic offences, ensuring that they're kept off our roads for a longer period. My honourable friend mentioned the sentencing guidelines. Let me turn to that specifically now. He's right. The revised sentencing guidelines came into force on the 1st of July 2023. And between the 28th of June 2022 and the 1st of July 2023, the courts were obliged to look to the old guideline. But, again, my honourable friend is right. As a result of the Court of Appeal case, in which I appeared in the Court of Appeal, the court did provide judges with guidance on how to sentence those cases in the in-between period. Judges were encouraged to apply an uplift to the provisional sentence identified to reflect the increase in the maximum penalty. And I emphasise that that happened in this case, and that the learned judge did quite specifically refer to the Court of Appeal case of Waite and Balthazar Soto. And I must mention and pay tribute to the work of the Independent Sentencing Council for its development of the guidelines. I understand my honourable friend's point about timing. He is right that it has taken a long time, but of course it is inevitable that it will take time for guidelines to be produced, following an appropriate consultation as happened here. And in the meantime, the Court of Appeal can give guidance, as also happened here. In terms of totality, my honourable friend mentioned concurrent sentences. Judges must consider totality and the totality of the offending when sentencing for more than one offence. The totality guidelines have also been revised, and the revised guidelines came into force on the 1st of July 2023. And the overriding principle of totality is that the overall sentence should reflect all of the offending behaviour, and it should be just and proportionate. In relation to the sentence and the offence of causing death by dangerous driving, the starting points and the category ranges relate to a single offence resulting in a sentence of death. And where more than one person is killed, as my honourable friend has said, that will, of course, aggravate the seriousness of the offence because of the increase in harm. However, where more than one death is caused and they are charged in separate counts, concurrent sentences reflecting the overall criminality is appropriate where the offending or the harm arises out of a single incident, but there will be an uplift, an increase in the sentence to reflect the increased harm. But I'd note the points that my honourable friend has made. Let me turn to his other points in relation to life sentences. Causing death by dangerous driving is a specified offence, Sir Roger, for the purposes of sentencing. This means a judge can impose a discretionary life sentence or an extended sentence if they determine the offender is what is known as a dangerous offender. A dangerous offender is someone who poses a significant risk of causing serious harm to members of the public. An extended sentence consists of a custodial term which reflects the seriousness of the offending, followed by an extended licence period, which is determined on the basis of what the court considers to be necessary for the purpose of protecting members of the public. And what this means is that, unlike a determinate sentence, the offender is not automatically released at the half or two-thirds point of the sentence. It means that they can apply for parole after they have served two-thirds of their sentence, in this case, and will only be released if the parole board determines that they are no longer a danger to the public. They must, of course, be released at the end of the custodial period, but will remain on licence until the expiry of the extended period. And the learned judge in this case explained that very process in her sentencing remarks. And on that point, I offer my sincere apologies to the family that my letter to them referred to the judge incorrectly. My honourable friend is absolutely right to raise this point. It was an error, it was my error, and I apologise. However, the case was carefully considered. They all are, but perhaps especially so those involving such tragic consequences, and especially so given that my honourable friend specifically brought this case to my attention. I'm grateful to my honourable friend for bringing this debate. The ULS scheme is not a mystery, nor should it be, but it's not often that we have the opportunity to debate the scheme in detail as we have done this evening, and I'm grateful to him for providing that opportunity. Specifically, he requested for me to meet him and the family. Yes, of course I will. Of course I will do that. And perhaps I should close, Sir Roger, by commending the family once more for their bravery in raising this case and for their determination to ensure that other families do not suffer as they have done.
The question is that this House to stand adjourned. As many of that opinion